In this particular one, it was a Queensland-based lawyer who had trouble finding a precedent and therefore decided to create his own precedent by getting somebody else's trust document and dictating it up. So actually had a dictaphone, sat there and dictated up the entire precedent, basically reading word for word somebody else's precedent. Had someone type that up, saved it into his Word documents and then started churning it out, to the extent that there were hundreds of these trust instruments set up. And as part of that copying processes and part of that dictating processes, he had to define the vesting date. And the definition that he chose to use was that the vesting date was 80 years from the date of establishing the trust, which was, as we touched on the earlier slide, totally permissible at law under each Australian jurisdiction and a very valid thing to go off and think about doing. The problem was this: when he did his dictation, what his typist heard was "18 years, 18, not 80 years. He didn't do a very thorough, admittedly this is with the aid of hindsight, he didn't do a very thorough reading of that trust instrument and proceeded to churn out hundreds of these things saying that the vesting period is 18 years. About 15 years later, somebody read the deed and said, we've got a huge issue here. We've got a trust that's going to end in about 3 years. We've got a whole lot of assets that if it ends and we trigger a capital gains tax bill, we're going to be in a big problem. We need to get this sorted. And the only way to get it sorted was to actually have a Supreme Court application where a whole lot of these trusts were taken through and the court was comfortable to rectify the typo of 18 and turn it into 80.